Well, hello and welcome to Split Informed and Split Smart. I am your host, Carl Roberts, and excited to be here for our show on the WGSN-DB Going Solo Network. The intention behind Split Informed and Split Smart is to help all couples, amicable or hostile, to more easily reach positive, equitable, and peaceful agreements in their divorce. I believe that most everyone in their right mind or not, deep down, wants peace, love, and equality in their post-divorce life. And that no one person should be able to deny that from the other or their children. That is the principle upon which SplitSmart was founded, a tool that helps everyone, regardless of emotional or mental state, better stay on course for a peaceful and more joyous ever after. But before solving problems, you must first understand their root causes. For divorce, we know that the single difference between a good and ugly divorce is simply the presence of a bad actor. Bad actors can be one or both, man or woman, lawyer or litigant. And we know that bad actors are typically good people who just got tripped up by their emotions, bad advice from friends, family, and or a lawyer, and often personality disorders of being a narcissist and or a borderline. With all that said, I'm excited to have our guest today, probably one of my favorite divorce lawyers, Mr. Joe Pickard from here in Colorado. Joe, thanks for being with us today.
I'm happy to be here. Thank you for asking me.
Well, for our audience to know, Joe is a little bit under the weather today, and so he toughed it out and showed up today. And Joe, much appreciated. Much appreciated.
You betcha. I'm not in good voice today, but I've got my tissue and my coffee, and you didn't have any sympathy for me, so I'm here.
Yeah, your email this morning says, "I think I can." It made me think of that little train engine, that little kid's train engine. I think I can. I think I can. Well, very good, Joe. Just real quickly, can I give our audience a brief introduction and background on you?
Well, I was born and raised in Texas. My parents divorced when I was about 13. We moved to Colorado. I've been a lawyer here for 39 years now. Went to high school here and the University of Colorado Law School. I practice primarily in the areas of divorce, criminal, and personal injury. So I'm pretty much a general practitioner. I've also had over 100 jury trials.
How do you like the jury trials?
I love jury trials. Now, and you may not know this, but jury trials existed in divorce cases until the 70s in Colorado. But that was with our fault-based system, which when we went to the Uniform Dissolution of Marriage Act, we got rid of that and went to a so-called no-fault system.
And how do you think that's played out? I mean, from the no-fault type topic.
Well, that's a great, I hadn't even thought of this. That's a great question. What happens in no fault is supposedly, if you read the statute, we're not supposed to be blaming one party or the other, just dividing things and figuring out how the property gets divided and what happens with the children. Maybe some maintenance issues, attorney's fees issues, but basically children and property. Well, what happens in no fault is you can't complain about the other person being a bad person, but you can complain about the other person being a bad parent. And so frequently, and as you know, in the property issues, if you can claim that the other person has wasted or hidden money, you can make them out to be a bad person with respect to the property. And so I think some of the no fault goal has been missed because it kind of surfaces in these other areas now.
Yeah, kind of as we've talked about, and as I start off with my preamble there. I mean, again, it's in a contested divorce. Well, in most any divorce, there's two things: there's money and kids, right? You either have them or you don't. And if you have them, there's potential for conflict and disagreement with it. And when you're more this litigious position or posture, then everybody's kind of lying about money, and the kids are all too often put in the middle. And that's just we talk about it being kind of the fact of life, the fact of this adversarial system. But again, you know me, I've been advocate for trying to change in different areas. But let's start on the kid side. Again, you know, one of the things that I criticize our courts for, that I criticize our statutes for, is that, you know, that they aren't serving the best interest of the child. They're trying to serve the best interest of a parent and or a lawyer, but they're trying to serve the best interest of the parent. And because, and again, kind of in my vernacular, you know, contested custody is just never about the best interest of the child. It's about money, control, and or hatred. Give me your commentary on that.
Well, again, you raise a great point, and this is kind of our history. You know, women and children were property until 100 years ago or so, and children were still looked as even referred to in one Supreme Court decision as so much chattel, so much property, and we've looked at it that way for a very long time. The very first child abuse cases in New York City in the late 1890s were brought under the Prevention of Cruelty to Animals statutes, because we hadn't progressed as a society where we were protecting children directly. And, you know, it's been a long, long time, and we're still struggling with that. You know, you made a comment earlier. I think it's so true that when I believe there are at least 4 parties in every divorce: the husband, the wife, the husband's lawyer, and the wife's lawyer, if you have them. And if any one of those is a bad actor, like you said, then you're going to have a problem. And so what have we taught everyone to do? We've taught everybody, go get the aggressive lawyer. Well, we get the aggressive lawyer, get the specialist, get the one that doesn't do anything except fight about this one thing. Well, that guarantees that you're going to fight a lot about that one thing.
And spend a lot of money.
And spend a lot of money. There's just no question but that's going to happen. And so you got to be careful, and there's got to be a nice mix of somebody knowing what they're doing and having some perspective. And that's why I think sometimes general practitioners like myself, or people that practice in 2 areas like criminal and family law, or family law and something else, can be a great service just from the concept or the perspective of looking at it a different way. You know, I got to say one other thing. It's said, and I think it's so important, that in the difference between criminal law and family law is in criminals, you have bad people at their best. And in family law, you got good people at their worst. And between those 2 things, it's a lot easier to represent a criminal.
And a lot more taxing on everybody involved. I mean, when you're kind of dealing with some of that black and white issue versus all the emotional issues, I mean, it's got to be a lot less taxing for lawyers.
Exactly right.
I mean, I think there's plenty of lawyers who have gotten into family law and said, that's it for me.
Yeah. There's something wrong with us if we do it for very long. Yeah, there really is.
Yeah. Very good. Very good. And so with our statutes and I'm an advocate, you know, so that, you know, again, every state has the best interest of the child statutes, and within that they typically have about 8 to 10 to 14 different criteria which the courts and I would say the divorce industry is supposed to kind of evaluate, you know, what's best for the child. But the one thing that the Colorado statutes do not do is that they do not recognize the importance and the value to the outcomes of the child having 2 healthy, loving parent-child relationships, and that just boggles my mind that parent-child relationships are not protected. And I know in my advocacy over the years, people kind of look at me, well, he's just a father's rights guy, or he's got the parental rights, and you know, but every study you kind of come across, with the exception of one that everybody kind of hangs their hat on, the lawyers do that argue against it, say, you know, kids do best with 2 parents. I mean, we know that in our brains and hearts and everywhere else, and all this, everything supports that. But it's such a battle to get what I would call a rebuttable presumption of equal parenting in the state statutes. several states have accomplished it now, and I'm hoping they're accomplishing it here in Colorado. But from your brilliant legal mind, why is there such an opposition to recognizing that that's the best for our children?
Wow, that's you're really just pummeling me with these questions today, aren't you? I think to begin with, the first reaction I have to a rebuttable presumption is that it would protect the bad actors. It would protect the substandard parent.
I think it's just absolutely the opposite.
Well, if you're a really bad guy and you look at your children as property and you just want to do whatever you want to do whenever you have time to do it, how does a rebuttable presumption of joint custody hurt you?
Well, I mean, so from the standpoint that so let's take it. Okay, let me just say it on a different way. So so obviously parents can, outside of court, kind of reach whatever agreement they want to, whether it's 90-10 or 50-50. It doesn't, whatever, because I'm a big advocate for shared parenting, but that doesn't work for every family, even in the most loving and good situations. So, and so parents in reason can get to that. But the problem has been for so long is that, again, without the rebuttable presumption, either parent, not in their right mind, can be pursuing more custody for money, control, and or hatred, not because it's best for the child, and they're trying to deny that other parent. And so right now, because we have no statute that says, well, prove it, I mean, we're saddled with this adversarial system,
mm-hmm.
where people are lying through their teeth in family court with no accountability. The false allegations of abuse are just rampant, and which takes away from all those real situations when it's true. There's my rebuttal to you.
That's right. That's a good start. I like that. I think if you think about the whole universe of people, first you have people that don't get married and have children, but let's say they get married and have children. And then there are those that stay married with children. Some of them should, some of them shouldn't. But because, and you and I have spoken about the studies that talk about it's not whether there's an intact marriage that's important for children. It's the level of animosity and conflict between the parents. And so you can have a good divorce and children come out of that much better emotionally equipped for life if the parents are getting along than in the cases where people haven't gotten divorced, but they fight every day. And so so you have married people, then you have divorced people, and you have those people in divorce who resolve their differences. They go to, they can handle it themselves. If they're past their emotional hurts, they can do that. If they can't, then maybe alternate dispute resolution where you're talking to a mediator or somebody like that who can help you resolve stuff out of court. And then at the end of the day, you don't fit into any of those categories. You're getting divorced and the parents have emotional problems, one or more of them, one or both of them, and then you're in court. So you're really talking about a small subset of all people. Okay. And so for me, in that circumstance, maybe this is just the way I look at it. If I'm heading for litigation and I'm in that set, whether I'm representing the one who's more emotionally challenged or not, it's going to be up to me to manage that evidence. And I don't really want, as a lawyer, I'm talking about, not as a parent. I might put that hat on in a minute, but as a lawyer, I don't want anybody telling me anything about the case other than the evidence that I want to put in and say that that this is best for the family or best for the child. Now, I have some background for that. I'm a child of divorce, as I said. I worked for the Department of Human Services years ago for 5 years. I couldn't keep doing that. And I've worked in the field of divorce law for a long time, but not ever where it was like all of my practice. And so I've gotten to choose a little bit more what kind of evidence I submit. But to me, that presumption, whether we start with that presumption or not, we're going to be arguing pretty much about the same things, because even under a rebuttable presumption, if somebody makes a false allegation of sexual abuse, for example, you're going to be in court arguing about that.
Well, but again, there's so much of it. I mean, again, when we got these custody evaluators out there who, to me, it's nothing more than a beauty pageant. Whoever they like best, or maybe who's paying them more, or whatever the case may be. That is, a problem. So because they're not kind of having to adhere to a 50-50 type deal without having some evidence that one of the parents are unfit, whether abusive or violent or addictions or whatever the case may be, or whatever the court may find. But that's where we have failed, in my opinion, is that we don't have to cite findings.
I agree with you. And let me say something that's counterintuitive and it's counterculture within my culture of divorce practitioners. I don't like to use custody evaluators or CFIs or they're called APR evaluations, allocation of parental responsibilities or rights. I don't like to use them for the same reason I just said. I don't want somebody else telling me what my case is about. If you've got good friends and family and you're a good parent, I can present that case without somebody else giving me an opinion about it. I can present it directly to the judge in questions that I want to ask, not something that made more sense to an APR evaluator. Imagine an APR evaluator has some sort of intrinsic or implicit bias one way or another. How are we going to get to that? I've got to take that on in addition to my case when I go to court and the judge is pressing us not to have a 5-day trial or 4-day trial. So it can be a real problem. And so I agree with your concern about that. I can tell you, I don't like to use APR evaluators and I don't like to use CFIs. The only time I really use them is when I have nothing to lose.
Yeah, and I think one of the things that you're really hitting on, the implicit or explicit bias, that goes for the courts too. I mean, that judge is up there, and again, so because going to divorce court, again, in my vernacular, is nothing more than a crapshoot.
It's a human legal system, and that's the real problem.
And humans across the span we're all flawed. And so because again, on a different topic, but not so much so, but there's no accountability for that judge, for the legal representation, for the litigant, for the CFI, PRE. There's just no accountability in the system unless you get to some extreme bar, which is again just the burden of reaching that bar is just most often insurmountable. But yeah, it is. So the rebuttable presumption, again, we got the numbers coming out of Kentucky who put it in. I think they passed it in 2017 and 2018. They started tracking the numbers, but the divorce, the domestic relation cases have declined 10% by the end of 2020. And the domestic violence cases have declined 18%. And so, there's not enough data there to make the full correlation. But again, in my belief is that, because in the rebuttable presumption, again, what kind of gets sideways on people at times is that's a backstop.
Right.
It's about, again, for normal people, figure this out on your own. And
Carl, that's the spot you told me I could disagree with you. So that's the part where I disagree, is that when you talk about normal people, you're not talking about people in a contested fight over their children. That is not their best day, and they are not acting normal. In fact, around our office, whenever a new client starts to say something odd or a little upset, when we have new staff here, they'll say that so-and-so's crazy. We say, no, they're not crazy. That's just normal crazy. It's just normal crazy, because that's what we deal with. It's a very difficult emotional situation. But you're really talking about those people in the worst possible situation when that comes up.
And again, because the subjectivity of the best interest of the child statutes, and I would counter that today is all subjective. It is any one person's opinion as to what those are. That if we put that one objective factor in, that you've got to, that you've got to meet or explain why not, then we start to narrow some of those emotions. We start to well, we know we can't win if we putting out some BS out there. We can't deny the other parent for our own or money control or hatred reasons. We can't do that. All right, and CC's prompted me that we need to take a break, so I better take that break real quick. But this is Carl Roberts with Split Informed and SplitSmart. There with my guest today, Joe Pickard, a Colorado divorce lawyer. We're talking about litigated divorce, and Joe's giving me hell for it. We'll take a break. We'll be right back.
When parents get divorced and become involved in the family court system, there are no winners. Everybody loses, especially the children. I know, because my custody battle lasted years, was completely unnecessary, and financially devastating. That experience inspired SplitSmart. SplitSmart is designed to empower both parents by giving them the structure they need to stay on course for a more peaceful and respectful co-parenting future. For less than amicable couples, our unique line item negotiation approach helps soften sometimes emotional stances into child-centered agreements that both parents can live with. Do you want your children to thrive and grow up with healthy, loving relationships with both parents? How much easier would it be if you could bypass the conflict and create a clear, supportive, and comprehensive co-parenting plan and schedule that's tailored specifically for your family? Can you imagine what it would be like if there were no arguments about money or child support? If any of this appeals to you, if you want to minimize the expense and drama of divorce, do yourself and your children a big favor and use SplitSmart to craft your co-parenting and support plans. And as an added benefit, even if you've done your best and still can't get all the way there, SplitSmart will have your information well organized, so a skilled mediator or family lawyer can efficiently help your family cross the finish line. Visit SplitSmart.com today to get started on creating a brighter and more joyous tomorrow for you and your kids.
All righty, Joe, how do you like that my ad there, that video?
I loved it. I hadn't seen that one, and I think it's fantastic. I think you're really on to something. Just without having a whole commercial about you, I think your idea is right on. If people can figure out how to argue about less, then the divorce is going to go more smoothly.
Yeah, and well, I appreciate you saying that. Yeah, I mean, it's just. And I talk about, organization, whether it's money or kids, it's just about getting organized. And with organization, that informs you. And then and it also helps for transparency. Just transparency of position is if nothing else. And by having that transparency of position, it kind of gives those couples those guardrails. Right. And so it helps lessen a lot of their emotions. And so they can kind of focus just focus on the facts and the black and white of it and try to get to more of it a lot more reasonably.
I can't tell you how many times I've been involved in a case where something that was, really not worth it was being fought about. Anything. It could be anything. One case, it was a Willie Nelson tape. Another case, it was a toaster. Seriously. But when somebody
the expense of just arguing about that stupid little thing.
And I won't do it anymore. I'm old enough where I can say, no, we're not doing that. But to begin with, you're supposed to, and you got to go back and forth. But I can't tell you how many times, Carl, somebody has said, "Oh, I thought you wanted that," or "Oh, that's what you meant," or "That's not what your lawyer said." Right? I mean, have you ever heard those things?
Yeah, I mean, just the changing positions is all part of the game.
And sometimes it's just how people feel about it that day. They don't really mean to restate it differently. It's just that today I feel about it differently. So I want that toaster or that Willie Nelson tape. Yesterday it didn't matter.
Yeah, it's okay. Yeah, I mean, again,
sorry, I
mean good people. No, good people in their bad days. Good people, in their worst emotion, because when people start talking, when they're less than amicable, and they start talking about custody and child support, naturally, I mean, it's totally naturally that they're more emotional about it. But that emotion, what's driving, what's the leading force there is that we're self-centered at that point. We're not child-centered.
Right.
And, so, sometimes it's easier said than done, but just the pure, one of the things that I coined that I really like, that kind of in our parenting plan, which includes schedules, but or kind of line item negotiation approach on the different items within them. And so again, for amicable parents, it's easy enough to kind of get through kind of one setting and just kind of document things and think about things that you may not have thought of, but you need to be thinking of, because you're going to have bad days in the future, and you need to kind of have a rule book to be able to kind of turn back to.
Right. I can give you an example, a little bit of how that works. The way I understand it works, I've seen your program, but I haven't implemented it fully, so I might not know. But if somebody's asked what time of day should the transition occur, you can agree on that even without a parenting plan. You can agree on the time of day or the place or the manner in which we're going to do that. It's going to be after school, or it's going to be at 8 o'clock on Saturday morning, or whatever people decide. In the usual course, and without something supporting that, where it's a line item negotiation, you're just going to say, well, you're going to get every other weekend and Wednesday evenings, and we'll figure out, how that's going to happen later. And then we don't. And so it's really nice. And I think it gives people some command of the, some confidence in what's going on when they can say, okay, we got this part settled. Now we just got to figure out what days. I think that's a good thing.
Yeah. And I mean, so again, just kind of keeping it simple. And so, and then later on, you can't claim that this one item blew up the whole deal.
Right.
So
it's already handled. Right.
Yeah. You start chipping away at your issues, and you start with the simple and go to the more complex. And, but yeah, so, I mean, again, to try to oversimplify some of this, my phrase that I coined is that, a written position softens a verbal stance.
Right.
And, again, so, I mean, we can all fire off what we want, what we think's right. But when we have to reduce that to words that other people are going to see, the first X and maybe the mediator, we don't want our words to betray us. Most of us don't. We don't want our words to betray us and say, and have my ex over there saying, look, see, he's in this for himself. We want to be putting down what we think is right, because it's right and child-centered, and it's for the best of us all. And so that naturally, just by putting it down in a transparent fashion for others to see, we naturally gravitate to something more child-centered and a more common ground.
I think you're right. I think you flip the system on its head a little bit. We generally work from, not always, in mediation it can work the way that your system sets up, but in general, we work from the more difficult issues down to what I call the minutia or the detail. But you can generate momentum in agreements by starting with something small, and then each side goes, well, yeah, you can do that. I can do this for you. And then you get into the habit of a little give and take. And then maybe you can start to see compromise as an area that's best for the children.
Yeah. I mean, I mean, I'm very pleased with, how my program's been working and the feedback that I've been getting from that perspective. And I think it's all about, and again, it's the transparency and, again, trying to be those guardrails to their emotions. And another thing that we've talked about, at length, is child support. And, and we're not completely in agreement on all these things, but again, we are more so than you will admit to. But because again, in my vernacular, in separating time and money to solve both more easily is something you do in your practice every day, or every time you're dealing with. Because when somebody's coming in there say, I want more time because of this or that. Well, let's examine that. So you're trying to steer people down that path of, okay, well, let's understand the time a little bit better. Don't worry about the money. We'll figure out the money later, but don't worry about the money. So I think that's something that I do really well within the application, and that feeds into what your beliefs. And then the other thing on where I get a little bit more in trouble with some of your peers is that for child support, again, I think most everybody wants to do the best that they can when they can. And we'll give willingly to our children, but for the extra benefit, if it's tarnished with the X benefiting with it, then that's where the conflict comes from. So more people that can distinguish between adult benefit of money and child benefit of money, just the more conflict that they can avoid.
And I'll put a sort of a exclamation point on that. When the new wife or significant other, and particularly when the new wife or significant other has children, that's going to put a lot of pressure on, and I'm saying wife in this circumstance, it could be, that's going to put a lot of pressure on the guy in that circumstance about the child support. And sometimes, again, these presumptions of child support can be correct. In a world that you and I created, Carl, maybe we just wait and see what happened and let the dad decide what level of support he provide his children. And maybe in many cases, he'd pay a lot more than what it is he's required to pay under our guidelines, right? I just read a separation agreement this week where the guy's going to pay all the medical care. He's going to pay to a huge amount of college expense, neither of which are required under the law. But that's what the parties, see, they're in that first group of divorcing people who were reasonable with each other and were able to do that. And this is what you're after. And that's why I'm a big supporter of you and what you're doing, is because we're trying to figure out a better way to get through this process, which is very, very difficult. And most people throw up their hands and just let the lawyers handle it. You're unwilling to do that and trying to find a better way. And I want to support that.
Well, and I appreciate that. And we talk about guidelines. I went through, I had a meeting yesterday with the Colorado Commission, and our guidelines. I mean, especially when in the lower income. I mean, so again, we talk about lower, middle, and upper income people, but the lower income in guidelines, if they're doing shared parenting, the guidelines have been paying almost 4 times as much as to what the actual cost of raising the child is based on U.S. Census data of consumer survey. In the middle income, it's about 350% more. And in the upper income, it's twice as much.
See, that's
just on the single kid. I mean, so again, when we talk about people getting tripped up, again, most people just want to do what they can best for the kids, and but when they get tripped up, they getting tripped up by money, control, or anger.
Mm-hmm.
And so the more that we can remove the financial incentive, again, some of your peers don't like me talking that way, but the more we can remove the financial part of the equation, and we make it more clear that it is truly about the child and not one another, then the better off the better off everybody is.
And on that point, I do agree with you. And as a child of divorce, I understood it also. I was 13. But And when I talk with my clients, I talk to them about what's best for the children. And when they start saying, well, how much child support will I have to pay? I say, we'll figure that out at the end. Right now, we're going to talk about what, when are you off work? When can you actually spend time with your children? What kind of activities are important to you where you're involved in your child's life? And then if we structure it that way, what I know in my experience, and I've been doing this 39 years, what I know is it's going to be a happier divorce. And the children are going to be happier when their parents are involved in positive ways that have nothing to do with how much child support's being paid.
And they both show up at birthday parties or school events and not make everybody uncomfortable.
That's the goal. The goal is for that to be best for the children. And here's what a lot of people miss. It's not just your child. It's your family tree. It's your grandchildren. And if are you a grandparent yet?
No.
If once that happens, man, all bets are off because you're gonna do what's required. And then it's their families and how they look at marriage and divorce. And it really matters. This is why I practice in this area. It's so important. One of the things we've talked about is really sometimes the lack of training for the judges in this area.
I was going to bring that up.
Well, because it's just so it dovetails with this issue. How important is this to families? It's so important. And unfortunately, I'll give you an example. Denver District Court, which handles many divorces as any place, maybe as much as all the other places, they're pretty good in general in their procedures. But in general, new judges get assigned to the domestic docket. And many of those people didn't, and I would say really most, if not all, didn't practice domestic relations before they got there. And then they may or may not get to what's called judges school before they even start hearing divorce cases because we're so overloaded. They've got a docket. They've got to get in the courtroom and start deciding things. It's very, very difficult for them.
And that's where court helpers of custody evaluators come into play. And but yeah, I mean, it just boggles the mind that domestic relations judges and magistrates don't have to have any specific training around families about custody, child support, and any of the other 15 other aspects of it. I think that is just, well, I don't mean to get too riled up here, but again, that is just abdication of responsibility on their part.
And for me, how do we balance that? I mean, criminal cases have to do with your liberty interests, so they have a priority on the docket. That whenever there's a criminal case, we're really suffering under the COVID era, restrictions. We've got backed up on a lot of things. We figured out how to do a lot of minor hearings and minor court appearances remotely, which is good. And we're mining out the backlog a little bit. But after criminal comes civil, and the next one should be domestic. And generally speaking, it is. But when you think about the training the judges have, and we have these judges who, some of them were great lawyers from great law firms in large buildings downtown, and they know how to deal with cases that deal with millions and tens of millions of dollars. But they've never been divorced, didn't come from a divorced family maybe, and don't understand why people who ought to be acting normally are acting crazy in their courtroom, and they don't know what to do about it. That's a really complex situation to put somebody in and then expect them to embrace all of that and figure out how to be fair and what's good for the children. Because there's just some arguments that are made the first 2 or 3 times you hear it might make sense, but the 200th time you hear it, you say, no, that's not going to work. And so in many states, we've got what are called unified family courts, where anything involving children goes into one courtroom. Dependency and neglect case might be in there, divorce case, or even personal injury cases that involve children.
We don't have that here.
We don't have that. And the advantage of that is what you're talking about is that the judicial officers there are trained and skilled or experienced in matters relating to children.
And there is a long history of obviously people dissatisfied with the family court. Certainly, I mean, it's acknowledged by everybody and their brother that it's the ancestor, that it's a unnecessarily adversarial system. And so, you look at different states, or different courts that have something more along the lines of, a judge who kind of took things into his own hands and did, has a specific little drug court. So people they're addressing these specific issues,
the problem
outside the box.
Right. It's a problem-solving court, the drug courts, for example. We should be looking at these family issues as problem-solving courts, but they're not. They're in this, we've plugged in the round peg into the square hole, and we've said, that's how we're going to handle these. It's going to be an adversarial process.
And then the closed ecosystem of this judicial bureaucracy that is immune to innovation or ideas that don't originate within their four walls is another point I get excited about.
We do sort of listen to ourselves within the field of family law, right?
So I mean, the only body kind of overseeing family courts is the Supreme Court Standing Committee on Family Issues. Who's on there? Judges, lawyers, a couple of mental health professionals, but not a single representative of a parent or a litigant who's been through that.
That really makes sense. I serve on the board that oversees the Office of Respondent Parents Counsel in dependency and neglect cases, and we have respondent parents on our board.
And I'm on the Child Support Commission as a parent. And we've got an open spot for another parent. But the courts have zero oversight, zero interest in getting that other viewpoint of their constituents. Boggles the mind. It just goes back to it's a closed system for the benefit of the lawyers.
And so let me circle back to something I mentioned earlier, and this ought to help anybody that listens or watches. I think it's very, very important to have some appropriate experience in your lawyer, but be careful about lawyers that try to pigeonhole you when you come in. Oh, this is a litigated custody case, so you got to do this, fill out this form, talk to this paralegal, but you're not getting a lot of guidance from the lawyer, or you don't have a match, a fit with the philosophy of that lawyer, that law firm. That's so important. The lawyer and the client end up looking like one another, psychologically speaking. So make sure you pick somebody that you think is attractive on behalf of your children, somebody that will advocate on behalf of your children in a way that you can support and get behind. Sooner or later, the lawyer and the client, they're going to be like each other. If not, they're going to part company.
Yeah, and to that point is, there's a lot of people who didn't have a choice about taking this route of a litigated divorce. And when we're put in that position, you're in a very defensive mode, and you're looking for that lawyer, if you can afford it, that bulldog, and that aggressive, adversarial, whatever. And that is, again, where so many people make that mistake. It's understandable how they make that mistake, but again, making that mistaken judgment about what they need, and they really have no clue.
Let me talk to the person that's hurting. If you recognize that you're hurting and you're acting out of emotion, one of the things that I sometimes even require of clients before I take them on is that they establish a really good therapist relationship. That person's going to charge you a third or less of what your lawyer is going to charge you, and going to do you a lot more good, because you're going to make better decisions, not as a legal matter, but as an emotional matter.
And the part that has a group that has really grown over the last few years are these divorce coaches. Right. And, so certainly men are, less than inclined to see a therapist. I see one, but
we don't like that. We don't like anybody telling us what to do, or that's
right, or how to feel.
If you recognize you're the hurting person, you better talk to somebody. That's what I'm saying. It'll save you. It'll save your kids. It'll save your life. It'll save you a lot of money. All of that.
Yeah. So find, again, for men, and I really appreciate you making that point, Joy, but well, for men and women, really, but go find a divorce coach. Therapists So and a lot of them have that therapeutic ability and style,
Right.
but they're also familiar with what you're going through a little bit more so than just the typical therapist. So I really appreciate you making that point. Joe, as always, we go long, but certainly a pleasure to see you today, buddy. I really appreciate you being here, your insights and perspectives. Let everybody know how to get hold of you, Joe.
Easiest way is through our website, which is lawpickard.com, lawpickard.com, LAWPICKARD, and that'll direct you from there.
Well, very good. And for those who have been brought into this just unwillingly, I recommend going to see my buddy Joe Pickard or Pickard, sorry, and then those who are just thinking about it again. They may be making the first move. I recommend going to see Joe, and it is again to make a more intelligent path and to get to better outcomes. Well, with all that said, thanks, Joe, for being here. My name again is Carl Roberts with Split Informed and SplitSmart. Please join us. I think it's November 30th. And my guest will be Dr. Jennifer Herman, who is a CSU associate professor, and she is, really internationally recognized as the leading researcher in parental alienation, which is, again, something that we need more awareness about. But thank you for joining. I hope to see you soon. My name again is Carl Roberts with SplitSmart. Find us at splitsmart.com, and we look forward to hearing from you. Take care. Bye-bye.